I think we may start again. Good evening, everybody. Thank you for being here to this second session of the conference. Unfortunately, the weather is really bad today, and that's quite surprising for this part of the year, but it will be not so sorrow to stay here and discuss instead of having a nice promenade in downtown Trento. Now, I have to introduce to you the presentation of Professor Alexandru Trevisono from the University of Minas Gerais, and more precisely from the Faculty of Law. Can you hear me? We have some delay in... unfortunately, the weather. To the legal philosophy in Immanuel Kant, but also he wrote on Emilio Betti and Hans Kelsen, and he has also other publications, especially on the discursive theory in Robert Alexis, and I think Professor Trevisono worked with Alexis himself. If you can hear me, Alexander, the floor is up to you for your presentation.
Okay, thank you. Can you hear me?
You're welcome.
Okay. So, first of all, I would like to thank the invitation from Professor Federico Pulpo, also from Professor Giuseppe Bellantuono and Professor Fabiano Teodoro. I'm glad to be able to participate with you per internet. I will talk about legal reasoning in the Brazilian Supreme Court. I will use a case or a group of cases to analyze the kind of argumentation the Brazilian Supreme Court has been developing, especially in recent times. So I begin with a short introduction. In recent times, jurisdiction has been playing an important role in many Latin American countries, especially in Brazil. After the promulgation of the new constitution in 1988, the Supreme Court, the Brazilian Supremo Tribunal Federal, which from now on I will term Brazilian Supreme Court or simply STF, has increasingly widened its role by progressively acting in areas it would not act before. If, on the one hand, many legal theorists see this wider role of the Supreme Court as an undesired judicial activism, on the other hand, wait a minute, I have a technical problem. Okay, on the other hand, the ones who wish a wider protection to fundamental rights have approved this widening of the rule. In this paper, I want to argue that the problem of the so-called judicial activism is not only the fact that the Supreme Court has been widening its role, that is to say, it's not only a matter of widening its legal competences, but rather a lack of rational justification of its decisions. In order to show that, I will take a topic in which the court has gone beyond the text of the Constitution and applied, or for some, created, a principle that should refrain the application of penal law in some cases, the cases of the so-called insignificance principle. I must say I do not intend to handle this topic from the standpoint of legal dogmatics, but rather from the standpoint of a theory of legal argumentation or of legal reasoning. Thus, my aim is not to solve the problems of legal dogmatics that are related to penal law, nor to solve the problems of the insignificance of the application of the insignificance principle, but rather departing from a theory of legal argumentation, criticized some arguments developed by the court, namely those used in the application of the insignificance principle. Now I move to my second point after this short introduction, which is the concept and the application of the so-called insignificance principle. This concept and this application are, of course, provided by the Brazilian Supreme Court. That it's not a concept that I myself am presenting. I am going to describe what the Brazilian Supreme Court understands by the so-called insignificance principle. So I begin with that topic. According to STF, the concept of the insignificance principle is connected to the idea that, exactly like in civil law, penal law does not handle cases in which the value is very low. De minimis non curat praetor. Intervention through penal law has to be minimal so that it does not rule questions that can be solved by other branches of law, such as civil law, administrative law, and so on. Penal law should have a subsidiary character, that is to say, it would be the ultima ratio, being used only when other branches of law fail. The majority of STF's judges say that one should consider not only what they call the formal elements of the crime, which in my view mean subsumption, but also its material elements, what the court calls material elements. And they explain, when there is no proportion between the illegal fact and the minimal damage to any juridical good, the elements of the crime are not present. An analysis of different STF's decisions in which the mentioned principle appears shows that different judges use expressions such as insignificant damage, minimal damage, tiny damage, and other expressions. Now I go to the analysis of the argumentation that the court has provided. I intend now to check, first, to which extent STF's criteria can really determine what an insignificant damage is, and second, what is the grounding for not punishing an action when the damage is insignificant. On the one hand, the first approach deals with the efficiency of the criteria, while on the second hand, the second approach deals with the correction of the adoption of the insignificance principle. So I begin with the efficiency of the criteria. At first hand, it has to be said that the insignificance principle seems to be something too general. Saying that, begin quotation, the judge should not handle what is insignificant, end quotation, is at least insufficient, for in order one can tell in a concrete specific case whether the judge must punish or not, one needs additional criteria to determine what insignificance means. Is stealing a chewing gum box insignificant? What about a motorcycle, or a brand new car, or a very old, economically valueless car? Does the significance depend on the victim, on the author of the offense, or on society? A 1,200 euros bicycle means economically few to a millionaire, but can mean much to a person who possesses only this bicycle as a means for transportation. But it can also mean much to a millionaire if it was a gift, for example, from a beloved one. STF has been considering the non-payment of one's taxes insignificant enough to justify the non-application of penal law when the value of the taxes that are not paid are under 20,000 reais, which means about 7,000 euros. But STF considers that stealing a good that is worth 9,000 reais which means about 3,000 euros, is not insignificant. Why? In order to try to solve the problem of the conceptual abstractness of the insignificance principle, STF has tried to establish supposedly more specific criteria, which I will term first, the offense criterion, which says that the action has to be offensive. Second, the social danger criterion, which says that the action has to be socially dangerous. Third, the reproach criterion, which means that the action has to be reproachable from the standpoint of society. And fourth, what I will term the damage criterion, which says that the action has to damage a juridical good. In my view, if we take a close look at these four criteria, we will see that these criteria are not really four different ones. Indeed, they are the general idea of insignificance formulated with different words. One can say, for instance, that the action has to be minimally offensive. That one says that the action has to be minimally offensive. This means that the juridical damage has to be irrelevant, for the action offends the juridical order in a minimal way when the damage is irrelevant, and vice versa. Besides that, when the offense is minimal and the damage is irrelevant, one could say that the action is not dangerous. Now, an action that does not damage, does not offend, and is not socially dangerous is not, of course, socially reproachable. Thus, STF's attempt to establish more specific criteria than the general idea of insignificance has failed. Besides that, even if this criteria had a differentiation potential, the individualization of their application would be missing. Former Judge Ellen Gracie, now retired, has pointed out two different important things. At first point, she emphasized that the application of the insignificance principle should not be made only by the application of an abstract criterion to a concrete case. That is to say, one has to look carefully to all specific factual elements of the situation. At second place, stressed Judge Ellen Gracie, the application of the insignificance principle should not be limited to analysis of economical value of the good. But what is interesting is that in most of the cases, Judge Ellen Gracie herself and her colleagues, the former colleagues and also the current members of STF, have not been able to escape the double booby trap of the abstract economical criterion. In order to show that, I will handle some cases of theft decided by the court. Here I have to make a short explanation. STF has been applying the so-called insignificance principle to different crimes: theft, possession of drugs by military in use, tax crimes, and many other different crimes. I will limit my analysis to theft for the sake of simplification, and also due to the time that we don't have much time. So I start with my analysis of some theft cases decided by the court. So, in the decision of habeas corpus number 92531.1, after saying that one should not ground the application of the insignificance principle only in the low economic value of the good, Judge Ellen Gracie justified the application of the principle by saying that the stolen value was very low. Someone had stolen 80 reais, which means about 28 euros. She also said that the victim did not remember exactly how much money she had in her wallet. When the victim went to the police, she could not precise whether she had 8 or 80 reais. She said she had between 8 and 80 reais in her wallet. Now, in the decision of another habeas corpus, in which the theft of circa 40 reais, which means about 13 euros, from the cash of a snack bar was analyzed, the same judge, Ellen Gracie, again, after saying that one should not ground the application of the insignificance principle only in the low economic value of the good, justified the non-application of the insignificance principle by saying that although the stolen value was low, which I already pointed, about 40 reais, begin quotation, the value was the result of an entire working day, end quotation. Let us compare the two decisions. The justification of the application of the insignificance principle was, in the first decision, the fact that the value was insignificant. And the main reason the value was considered insignificant was that it was so low that the victim could not remember exactly how much money she had in her wallet. Now, in my view, this reasoning is at least problematic. If one asks me how much money I have in my wallet right now, I honestly cannot tell. But this does not mean I don't have much or little. It means simply that I don't know. Let us imagine the following. One person does not know that an amount of money has been deposited in her bank account. Imagine, for instance, she has forgotten that someone would make a money transfer to her account as a payment for a house that was sold. After this deposit, the person has about 600,000 reais, which means about 200,000 euros in her account. But she simply forgot the other person would make this deposit. Imagine now a hacker accesses this account and takes all the money which is in the account. In a moment, let us repeat, that the person has forgot how much money she had. If we follow the reasoning STF applied in the first aforementioned decision, we would have to conclude that the value in the account was insignificant, and thus no crime was committed. Now, in both cases, that is, in the case of the wallet theft decided by STF, and in our hypothetical case, the fact that the victim does not know how much was taken does not mean that the value was insignificant for her. In the case decided by the STF, the victim did not remember exactly how much money she had in her wallet, but maybe the value she had in her wallet was the value she receives as payment for an entire working day. Exactly like the case of the second decision, the theft of a snack bar's cash. One can easily see that STF used two different criteria. In the first decision, 80 to 80 reais was considered an insignificant value for the victim because she did not remember exactly how much money she had. In the second decision, 40 reais was considered a significant value because it was the result of an entire working day. Thus, STF treats similar cases differently without saying why. Let us imagine a final hypothetical situation. Let us suppose that one steals a snack bar and the stolen money was the result of the entire working day. But let us imagine that the cashier does not know exactly how much money was stolen. What would STF decide in such case? Will this value be considered insignificant because the victim does not know how much was stolen, or will it be considered significant because the stolen value was the result of a working day? So we see that we have a problem. The court doesn't have a criteria or a group of criterion to determine what is insignificant or not. I could mention other examples. I have many here, but since we don't have time, I will limit myself to this example. So the first point was that the criteria are not efficient. Now I move to the second point about the justification of the insignificance principle. So how can the insignificance principle be grounded? When such a question is made, a group of normative reasons are expected as an answer. That is to say, it is expected that one presents a group of reasons that justify why insignificant damages ought not to be punished. But what has STF been saying about such grounding? In most of the cases, STF has just limited to repeat what Judge Celso de Mello said in a case which was decided in the 90s. According to him, I begin quotation, the legal system has to consider that hindering one's freedom and rights is justifiable only when it's necessary to the protection of persons, of society, and of other juridical goods that are essential to them. End quotation. Quoting dogmatic arguments, Celso de Mello recognizes that the insignificance principle is not foreseen in any statute, nor in the Constitution. But he understands that, I begin a new quotation, considering the principle of the minimal intervention through penal law, which is addressed to the legislator, and the postulate of insignificance, which is addressed to the judge, penal law should not handle actions that produce a result which does not represent an important damage. End quotation. But Celso de Mello does not mention where the supposed principle and the supposed postulate come from. He simply says that there are both a principle and a postulate, the first addressed to the legislator and the second addressed to the judge. He doesn't mention any norm, any argument, or any reason to justify where these principles or where this principle and this postulate come from. I come now to my conclusion. If I am right, although STF has been systematically applying the insignificance principle, the court has not been able to represent a well-defined concept of insignificance. That is to say, it has not presented criteria that are able to differentiate insignificant and significant damages. Besides that, the court has also not been able to justify this principle. That is to say, the court has not presented reasons to show that this is a valid principle within the Brazilian legal order. But how could that be done? The first thing would be clearly presenting dogmatic arguments that ground the insignificance principle. As we have seen, the courts, and especially STF, justify this principle in a very unclear way. They mix different ideas and theories so that it is not possible to clearly identify what their groundings are. From an analysis of what STF says, we can try to organize the following reasoning that the court is trying to express. So now I try to extract from these very mixed and unclear arguments step-by-step reasoning. The first step would be, step one, I call it, according to the principles of contemporary penal law has a subsidiary character. That is to say, intervention through penal law has to be minimal. The old Roman proverb, de minimis non curat praetor, already pointed in this direction. So that's the first step of the argument. Now comes the second step. Because of that, penal law should punish only what is insignificant. So the first step was that penal law has a subsidiary character. The second step is, if it has a subsidiary character, it should not punish what is insignificant. Then I come to the third step. The damage is insignificant when it damages no juridical good or when the damage to a juridical good is minimal. Then I go to fourth step. The criteria to know whether the damage exists or not, or whether the damage is insignificant or not, are the offense criterion, the social danger criterion, the reproach criterion, and the damage criterion. Now I go to the fifth step. When this happens, that is to say, when the damage does not exist or when the damage is minimum, according to what STF calls material elements of the crime criterion, no crime was committed. Then I go to the last step. This interpretation is supported by penal law, contemporary principles, which mean that penal law has a, quotation, subsidiary character, end quotation. That is to say, penal law would be the ultima ratio. When we organize the unclear STF's arguments, we can see that besides not quoting its sources, worst of all, STF does not ground its premises. Premises 1 and 2, in which STF is defending a subsidiary penal law, are not justified. Amazingly, STF says at the same time that, like civil law, penal law should handle only actions that are insignificant, and that penal law should be used only when the other branches of law fail. I want to stress here that STF says two contradictory things. On the one hand, it's, so to say, compares penal law to civil law. On the one hand, it says that penal law, exactly like civil law, should handle only what is significant. And on the other hand, it says that civil law should handle more than penal law. Now, should other branches of law not handle what is insignificant, or should they handle all? That is, even what is insignificant. And only when they fail should the matter be handled by penal law. STF does not answer this question. In steps 3, 4, and 5, STF grounds the idea that insignificant actions should not be punished by using the idea that there is in such cases no damage to any juridical good. For these actions are not offensive, are not dangerous, are not reproachable, and not damaging. And then when we consider the material elements of the crime criterion, insignificant damages are not punishable. Now, STF does neither explain nor ground this argumentation. That is to say, it does neither provide a clear concept of material elements of the crime, nor does say what is the most adequate, nor show that there are in such cases no damage to any juridical good. By mixing arguments without any organization, STF only makes things unclear. STF should handle a debate, deepen the discussion, make its points clear, and ground its argumentation. Regarding steps 4 and 6, the 4 criteria STF presents do not really differentiate significant damages from insignificant ones. Thus, STF does not ground the principle it applies. In my view, both the definition and the justification of the insignificance principle should be preceded by a discussion about the nature of punishment itself. Unfortunately, it is not possible to handle such discussion here. Yet, what has been said is enough for the purpose presented in the beginning. The application of the insignificance principle lacks rational justification. I will finish now. I analyzed a case, and one could object, you took only a case. Like I said, regarding the application of the so-called insignificance principle, one can find contradictions and unclear arguments in the analysis and in the decisions of every case the court has decided. In my view, in other topics too, the reason for that might be that the court adopts what is called the seriatim model, in which the judges present their own opinion and they do not talk with each other. I mean, sometimes they do, sometimes they fight, but they do not handle a discussion, and in the end, somebody writes the opinion for the court. In my view, if the court would adopt the per curiam model, like, for instance, the Supreme Court of the United States does, this problem would be minimized. What we see today is that because of the lack of rational argumentation in the individual opinions that are written by the judges, together with the seriatim model, which is adopted by the court, it's really easy to criticize the decisions. They are incoherent, and so in my view, they lack rational justification. Thank you very much.
Thank you, Alexander, for your very interesting presentation, showing us some way that how remarkable is the use of argumentation in judicial cases, and in judicial field included the constitutional one. And I think that legal argumentation should be studied more and more in the law faculties in Italy too. Our second discussant today is Federico Pupo from our own faculty, which is also the secretary of the Research Center on Legal Methodology. His main studies are on legal epistemology and judicial rhetoric and artificial intelligence and the law. So Federico, the floor is up to you.
Thanks, Maurizio. And first of all, what is really impressive to me, as for Simone, is that from a theoretical point of view, we are discovering a very deep ground, common ground with our Brazilian friends and colleagues. Since, as Professor Trevisono explained to us, one of the main problems in Brazil, and I think in Italy too, is that now we lack a tool to evaluate argumentation in court, and particularly to evaluate from a rational point of view what judge says. And this is exactly what I'd like to discuss with you, just to present some reflection about legal reasoning and discussing the nature and the structure of legal reasoning, analyzing the problem of rational control in legal decision. And I would like also to discuss with you the nature of legal science, which is, from my point of view, really connected to the idea of rationality embodied by the model of legal reasoning we should build. From this point of view, I think that it's a common knowledge to say that the modern idea of law has a clear representation about the nature of legal reasoning, since, as everyone knows, in modern time, law is restricted to the dimension of norms, as to say the formal will of the state. And so legal reasoning must be only the application of norms to facts without any kind of interpretation. The aim of this kind of legal reasoning conception is to obtain certainty in law, because we would like to repeat the objectivity we find in science and in deductive reasoning. Thomas Hobbes, Cesare Beccaria, Montesquieu are the main supporters of this kind of utopia, because they are very effective by the epistemology of Galileo Galilei and Descartes, and they would like to force the scientific method of knowledge into law. So the modern idea of legal reasoning is the model of the so-called practical or legal syllogism. A syllogism in which the major premise is the law, the minor premise is the fact, and the conclusion is the subsumption of fact into law. A syllogism which is, as Beccaria says, perfect syllogism, since we could not discuss the description of law and the description of facts given by the judge, who is the only subject authorized by legislator to speak in its stead. Is it possible to avoid this kind of echo, no? Okay. Professor Trevisono, sorry. You listen to me, yeah?
Yes, I do.
Is it possible for you to switch off the volume? We hear a echo. Is your mic, just switch off your mic.
Okay, I do that.
Thanks a lot. we try now. Okay, thanks a lot and sorry for this. The judge, as Montesquieu says, is la bouche de la loi. And the law is all represented into codes. And the code is ready to be mechanistic applied by the judge herself. This kind of perfection sought by the fathers of modern idea of law is really coherent and tied with the model promoted by scientific method, a model of knowledge which is not evaluative in itself. And this kind of method became the method. Since if you want to be rational in every kind of knowledge, you have to think to work as a scientist. This is the only method you have to adopt if you want to make a scientific analysis of something. Despite the process of time, still at the beginning of last century, this is what Rudolf Carnap and Wiener Kreis maintain as a general rule of thought. And this is the ideal we find in legal positivism, for example, and in analytical philosophy of law, to build up a so-called legal science, complying with the methodological monism of modernity. To be a legal scientist in this perspective means to do the analysis of the speech of legislator and to look at this kind of speech as an object. But now, as everyone knows, this kind of model is in crisis. If we look at legal reasoning, and I will come back to legal science at the end of my speech, we should remember that some of the main criticisms regard major premises problem. As hermeneutics explain, it does not exist an evident and objective meaning of textual provision, and norms are the result of complex operation of interpretation. It is also clear that it is not possible to look at facts, what is the minor premise, in terms of descriptivism. According to epistemological outlooks enclosed by the criticism of contemporary philosophy of science to modern idea of knowledge, now it seems more suitable to speak about storytelling of facts or about construction of facts, and there is no lack of hermeneutical explanation for construction of legal facts. Besides them, we've given up the idea of reasoning as a sort of deduction and reconsider the crisis of positivistic paradigm of knowledge. The form of legal reasoning is now better described in terms of constructivism or as a complex set of rational operations in which, for example, abduction plays a constitutive role. And all this kind of new construction of legal syllogism could be assumed into a complex set of operations which are normally called argumentation. In fact, after the so-called argumentative turn of last century, we are in 1958 with Perelman and Toulmin, it became more and more clear that it is impossible to apply scientific methods to the realm of discourses done in dialogical and rhetorical contexts. And so, since the 70s, scholars are searching for a new, but as for myself, a really old model of knowledge to describe and evaluate argumentation, trying to understand what kind of method argumentation is, if argumentation is a rational method or not, and if it is a rational method, what kind of rationality we should find in it. Several theories about argumentation have been obviously developed, and I do not intend to discuss it with you today. What I would like to do is rather to discuss with you my proposal, which is the proposal developed here in Trento by our research center on legal methodology, founded and directed by Professor Manzin 10 years ago, and obviously 2014 is a very important year for celebration in this university, in this faculty. And this is a center to which I belong to. First of all, I will remember to you our problem. And this is the problem also for Professor Trevisan. For several centuries, the model of legal reasoning was the one of legal syllogism. It is the only way by which it is possible to maintain rationality in law. If you want to be rational in law, if you are a judge, you have just to apply legal syllogism. You must follow the scientific method, so to say, deduction. Now, this model is in crisis. And what we have now is, as Professor Trevisono says, uncertainty in law, with no reason and only with the problem of a free will of judges. So, what we are searching is now, as for Beccaria, rationality in law. But, is it possible to evaluate and to control from a rational point of view what a judge says? To answer to this question, I think that it's important to answer to another question. When we speak about law and application of law, what do we intend? Obviously, we intend trial. So to say, a context characterized by the presence of judge, and this is for modern thought too, but also by the presence of two parties, the lawyers, completely forgotten by modern legal thought. Trial, in its own nature, is a special kind of dialogue. And I think that the rediscovery of dialogue's dimension is the main thing which allows us to find out rationality in law. So, foundation for argumentation. I believe that a good way to understand what dialogue means is to look at dialogue from a philosophical perspective. Namely, to remember that in Western philosophical tradition, and now I'm quoting Enrico Umberti, who is one of the main important philosophers in Italy, quotation open, philosophy has been essentially seen as logos, in the great sense of the word, namely not as a mere discourse, semantic or apophantic, but as argumentation. With argumentation, I intend a discourse which is not limited to say as things stand, but which tries to justify, to motivate, to demonstrate what it asserts, to bring reasons, to account for itself. Quotation closed. As well know, the distinctive form of argumentation we find in philosophy is dialectical confutation. That is to say, to see what is it true or not, just verifying the possibility of a statement of contradiction of it, using the principle of non-contradiction and the principle of excluding middle. This kind of argumentation, as Enrico Berti says, I'm quoting, takes necessary place within the frame of a dialogue between two persons. Each one of them claims a thesis conflicting with the thesis of the other. Quotation closed. So, what we have is a strict relationship between dialogue, between argumentation, between confutation and truth. And this is the reason for which, when we speak about dialogue, we have to intend, according to Berti again, quotation open, that dialogue in a strong sense, it is not simply a conversation, but it is a discussion. A comparison between theses, aiming to determine which of them is true and which of them is false. From this point of view, dialogue, it is not a mere state of affair, or a behavior, a sign of willingness to listening, to respect of others, to self-criticism. Dialogue is the condition of dialectically arguing, and so of philosophically thinking. I consider dialogue not simply a fact, but a transcendental structure of argumentation, given its not monological nature, which is dialectical, therefore dialogical. Quotation closed. So, according to this lecture, to this philosophical position, which is really our philosophical tradition, is it possible to date back to Parmenides, to Plato and Aristotle, the link between logos, dialogue, argumentation and truth is undeniable. Logos is, however, a word which has with many meanings, such as discourse, argumentation, but also reason and logic. In this way, our philosophical tradition points out to us a model of knowledge in which all those elements are in some way strictly interconnected. So, if we speak about argumentation, we should remember that it is not possible to conceive argumentation without logic, so to say, without a control about the dialectic value of discourses. But if dialogue between two parties is the typical structure of philosophical debate, what is typical of law? Trial is not mere dialogue, because in trial we have a dialogue between two parties in front of the judge. And when we are in trial, the party has the duty not to persuade the other party, but to persuade the judge. It's the judge who has the duty to say who is right and who is wrong. So, to remember the dialogical nature of trial is to say to remember the dialogical nature of legal reasoning. So, to remember to us that it is impossible to represent legal reasoning as a monological reasoning. When a judge makes her own reasoning, she is speaking before two parties and she has the duty to collect and to evaluate all the discourses made by the parties. The judge is a third party, part of a so-called trilogue argumentative, and she is not alone. From this point of view, the proposal of our research center is for a so-called cooperative argumentative legal syllogism, and this is expressly studied by Professor Manzin. A model of legal syllogism in which we should maintain that judging is to apply law to fact, if and only if we recognize that law is founded and interpreted at first by parties and then by the judge, and that facts are offered only by the parties to the judge in respect of the so-called due process of law. The judge has not the possibility to find out the truth about facts. And that, at the end, subsumption of fact into law is not a procedure given in automatic way, but it is the outcome of choices which must be justified and motivated. What Professor Trevisono told us is that the problem with the Supreme Court in Brazil is just, for example, that for insignificant principle is never good, grounded and motivated by the court. So, legal reasoning, in our perspective, is a complex set of operations built up by the cooperation of all the subjects involved in trial, by the parties and by the judge, in which also pathos and ethos, the pathetic and the ethical value of argumentation, play an essential role for constructing the reasoning. At the end, what about legal science? As for trial, it is now impossible to maintain what modern legal philosophy says, and so the validity of a model of knowledge, monological and non-evaluative. What we have now in law too is pluralism. We have pluralism in law, pluralism in methods, pluralism in values, pluralism in logic. We do not have any kind of objectivity to which we should look at to have certainty. But it does not mean that we do not have more space for rationality in legal science. As for legal reasoning, I really believe that rationality in legal science, or to say better, in legal knowledge, is given by our continuous asking and answering about our opinions in law, explicating our ideas and our beliefs. In a word, having dialogue and discussion. And so, another time, argumentation. And this is what I hope to have done with you today, and I hope this is what we should do in the near future with our friends from Brazil. So thank you very much for your kindly attention.
Thank you, Federico. You finished in a short time, so we have more room for discussion. And thank you for stressing the importance of the dialogical structure of legal reasoning. According to Federico, the application of a scientific formal deductivism is unfit for legal decision in trial, but also in judicial review, I mean. And we should look for a broader form of logic, maybe. So I think this is time for the debate, and please, any one of you who has something. Yes, and.
But I think that Soraya, Simone, and Dimitri could reach the table again just to answer a question. I don't know if they are here. Just outside, okay.
So. Two.
So first, thank you for the inspiring presentation. My name is Lucila, I'm Brazilian, and I'm PhD research in European University Institute in Florence. I have two questions, actually. And, okay, the first one is regarding when you come and explaining the insignificance principle and why and how the court agree about the importance of insignificance principle as a derivative principle from the principle of minimum intervention of criminal law. And then I have one question. My first question to you would be like, I'm not familiar with the decision of the Supreme Court. I'm not a criminal lawyer, but I would be very, very curious to know whether the judge in the Supreme Court, when they set this principle of insignificance principle, they don't use as an argument as well the fact that the Brazilians, it's a well-known fact, that the Brazilians, the jail in Brazilians are crowded and they don't have capacity anymore to include persons that was condemned in criminal process. And then if he uses this argument, and then it's an instrumentalist argument to the law, to set the principle. And one thing that I'm not sure, but it's if he uses this argument, if he brings this fact to it's not only legal reason, but it's also an instrumentalist argument to law. My second point for your presentation would be like you said that the Supreme Court, when they set the insignificant principle, they bring the 4 criteria. But actually, when you look how the Supreme Court is applying these 4 criteria, they are applying, there is a lack of justification. But then you come and bring in examples of how the Supreme Court has decided, and actually, I have the impression that actually I don't see the lack of justification because the Supreme Court are bringing a justification. Actually, what is lacking of is integrity, like coherence between decisions and how they are applying this criteria. So I would ask you, like, this is a lack of justification or there is a lack of integrity? And I mean integrity in the working sense.
Okay. Can you hear me? Yeah, thank you. Thank you. Can I answer now or should we? Yeah. Thank you very much for both questions, which are, by the way, very interesting. The sound is not really good, but I think I understand the core of both questions. So, if I understood correctly, you have your first question is about the fact that the court could maybe justify the application of the insignificance principle by saying that jails are full. That might be in my view, the court will never do that, because that would be no juridical argument. It would be too inconsistent if the court said, okay, it is fair that we punish these people, but since there are no places enough, let's not punish them. Maybe this is the real reason they do that. But like Professor Pulpo said, argumentation is a dialogue, and a dialogue which is conducted between people in court. And here I use the criteria presented by by a philosopher from New Zealand, who now is in the USA, who is Philippe Petit. He said, something is rational when you are able to present an argument in public and justify this argument intersubjectively. So maybe the real ground, the real reason, let's say, why the courts do not want to punish these people is that jails are full. But if this were a reasonable argument, it should be able to be presented in public and defended in front of other people. So that's my answer to your first question, which is, like I said, it's interesting. So I think it might be a, so to say, a secret reason, but it's not a rational argument because it cannot be presented in public. Regarding the second point, which is the lack of justification, you're right. Someone could say they present an argument because they say what an insignificant action is, these 4 criteria. But like you yourself recognized, these arguments are not coherent. So I take as a first argument to say that there is a lack of justification your own observation. In my view, a justification which is not coherent, in my view, is not a justification. A justification has to be coherent. You mentioned integrity. I agree with you. One could say there is a justification, but there is no integrity in this justification, or there is no coherence or no consistency. But in my view, since I understand that a rational argument cannot be a contradictory argument, in my view, when one presents a contradictory argument, one is not really presenting an argument. So that should be enough to note or to perceive that the court is not really justifying what the court is deciding. But then there's another point which has to be stressed. The court never says where these principles, where these premises that the court is affirming comes from. Of course, we should not demand that the court always grounds an affirmation on another affirmation, because in this case we would have regressus to infinitum, and that's not possible. But in my view, the court is really not presenting arguments. Like Professor Pulpo stressed in his lecture, I think what's happening with the courts in Brazil is the following. In Brazil, the courts were used, I would say, for 30 years, were used to apply the syllogistic model. In the history of legal philosophy, we know that since the 19th century, this model is not enough anymore. Then, with the new constitution, a new model was created. The judge should not only apply the law in this mechanical way, but should ground. But the courts and the judges are not ready to do that. And so there is a lack of the justification. In my view, a constitutional court has to have as the source of its arguments the Constitution. When I talk about a lack of justification, I say that apart from the incoherence, I mention that because the court It's amazing. When applying the insignificance principle, I searched for more than 50 decisions. In none of them, I found a quotation of a part of the Constitution. Isn't that interesting? A constitutional court that decides an important case, and then you search for more than 50 decisions, and you do not find any reference to the Constitution. They talk about legal science. They say that this principle is recognized by legal science. They mention some legal theorists, like for instance, they mention some Brazilian legal theorists that mention the insignificance principle, and they mention also the well-known Argentinian lawyer, scientist Zaffaroni, and so on, but they do not mention the Constitution, not even one single time. In my view, if the court, what I want to stress here is that I do not criticize the idea itself. In my view, the idea that insignificant actions should not be punished seems to me rational. It seems to me rational. What I criticize is the lack of justification from a constitutional court. From a constitutional court, one would expect legal arguments, not arguments from common sense. And just to finish, because I'm talking too much, you mentioned the 4 criteria. In my view, like I said, I tried to show, maybe it was not clear or not. The 4 criteria, the social danger, the damage to the juridical good, and so on, they are a repetition of the idea that what is insignificant should not be punished. I may agree in general with the idea, but I find that the idea is not justified by the court.
A question for you, Professor Trevisan, Federico Pupo speaking. I think I agree with you about coherence, but not really, because absolutely coherence is the main tool for argumentation. You listen to me? Yeah. Okay. But it's not enough. Probably she's right when she's asking something about this, because in my opinion, coherence has to do with the logical value of argumentation, with validity. But we should think about an argument perfectly coherent in itself, but wrong. When we speak about argumentation, we have also taken into account the soundness of an argument. And this is what is really connecting the theory of argumentation with a dialectic value of argument. So coherence has to do with the structure of an argument. It is the logical point of view, okay? But soundness has to do with what we say. So about the fact if an argument is wrong or bad, is true or false. And my question to you is, according to you, how is it possible to evaluate the soundness of an argument? I have my opinion, but I would like to know what you think about this. The second question is, do you think that integrity has to do with ethos? And the last question is, when you're speaking about the justification and the need to ground an argument, you mean something like a problem for a topical activity? So do you think that, for example, it's important for the judge to taking into account the constitutional too, and not only, for example, scholars' opinion and so on? And if I can make a question to my friend Simone Penasa, my question for him is, we are speaking about the problem of judicial activism, and you told us that also in Italian experience we should find something similar. And you find something similar about this problem we are discussing with Professor Trevisan in the experience of our constitutional court or not? Thanks a lot.
Should I answer now? Yeah, I would like to answer I didn't understand the third question, so I will answer the first and the second questions, and then I would ask, after I answer both, I would ask Professor Pupo to repeat them. I will try to be brief because I know there are other people should talk. So regarding the first question, coherence and soundness, I agree with you. In my view, coherence is not sufficient, but it is necessary. So I would say it's not a sufficient cause, but it's a necessary cause in order we have a reasonable argument. So if coherence is only one requirement but is not enough, what then is the requirement in order an argument is rational? I used to evaluate whether an argument is sound, like you say. I use the theory of discourse in a way Habermas presented it, but in the way it was developed by Robert Alexi, with an addition of an argument used by Philippe Petit, which means the following. For me, an argument is sound if this argument can be accepted by my partners in the discourse. This is too general, and then we have, of course, the rules of legal discourse. I accept all of them, the ones that Robert Alexi presented in his theory of legal argumentation. So the argument should not be contradictory. The one who says something has to justify that. The so-called argumentations last, the burden of argumentation. One should not be contradictory. One is asked to ground his argument. One should do that. Okay. And then one thing that I add at this theory, which in my view might be said to be implicit there, is the publicity argument, which was, by the way, already present in Kant. Kant talked that a moral maxim is a maxim that can be publicized. So in contemporary legal philosophy, I see this idea in Philippe Petit, in his book, A Theory of Freedom, when he says that an argument is rational when it can be defended in front of a public audience. Okay, that's the first question. The second question is a very interesting and difficult question, is the question about the role of ethos, of ethnicity. Of course, that would depend on the meaning that we give to the word ethos. But I will assume that you're talking about material ethnicity, which means the customs, the social rules of a group. So if we understand that that ethos means material ethnicity, I would say that, of course, it should be considered in order to evaluate legal argumentation, but it should not violate moral arguments. And then I would say moral arguments do not have to do with material ethnicity. Moral arguments have to do, in my view, with the principle of universalization, in the way Kant presented it, and in the way Habermas and Alexi developed it. So it was what I talked about when referring to the first question. A moral argument is an argument that is related to what is good for everybody in a rational discourse. An ethic argument is what is good to our community. In my view, what is good to our community, we have discretion to moral leaves us a leeway to decide what is good to our community. So there are things that, in my view, are equal in Italy and in Brazil. But there are things that have to do with our material ethnicity, and that we Brazilians have, so to say, discretion to rule in a different way of the Italians. So I think this is the role of material ethnicity, but I don't see that as integrity. In the working, it might be the case, because in the working, in my view, material ethnicity is part of his theory of interpretation as integrity. But if I would write a book about legal interpretation and the role of integrity in legal argumentation, I would not put material ethicity as integrity. Integrity for me would be coherence between all the normative system, not and then other things would come. So the third question, I really didn't understand the question. If you would...
Just to understand, when you speak about the justification of an argumentation, are you referring also to the first phase of rhetoric? It is the topical activity. We have to find out the best loci argumentorum to justify our argumentation. Is it right for you?
If I understood correctly, you're talking about, you mentioned topical argumentation, isn't it? Okay, so I will try. The sound that comes from there is not really perfect, but I think I understand what you mean. In my view, legal justification has to do somehow with topic, because of course you need, in the way Vivek presented the term, of course you need some common places from which you have to departure. But here again, I think that Robert Alex's theory of legal argumentation is a good model, because it takes seriously not only moral or general practical arguments, but also specific legal arguments. So for him, as we know, juridical argument is a specific case of general practical discourse. What does it mean? It means that in juridical discourse, I am allowed to use moral arguments, universalization principle in the form of discourse, intersubjective, like you said, but also we have to take seriously juridical arguments. And that's, I don't know, I would like to be there with you to discuss with you later how is it in Italy. But in Brazil, we moved from a system of taking legal arguments too seriously before the Constitution, and today some judges, not all of them, Professora Monica, who is there, is an exception, but some judges forget the law and they decide only with moral arguments. So I take the argument from Robert Alexi that legal argumentation has to take law seriously. And what does it mean? It means taking seriously the law, legal statutes and the Constitution, legal dogmatics, which means legal science, and of course, precedents. So in my view, these are the three places where one, not only the judge, but a scientist, finds specific legal arguments. And then he can search for moral arguments, and moral arguments have a role in law. But then a problem which we don't have time to discuss is when legal arguments confront moral arguments. Is when we have, for instance, a statute that is incompatible with a moral argument. But that would be another question. So for me, the places where we find arguments to be used in legal argumentation are morals, in the sense of intersubjective discursive universalization, statutes, precedents, and legal science. I hope to have answered your question.
Yeah.
Okay. You mean if the question was about the legal reasoning of the Constitutional Court,
legal reasoning about the problem of judicial activism.
Because is as I mentioned before, judicial activism also in Italy is a very hot issue, and the maybe paradoxically, the first season of the effective implementation of the Italian Constitution was made through so-called judicial activism. So also on the ground of the specific interpretation made by the Constitutional Court of the role and nature of the Constitution, many judges were pushed to find within the text of the law the meaning which more was coherent and consistent with both constitutional rights and constitutional principle. And if you think of on all these interpretative means, such as the interpretation consistent with the Constitution, of the direct implementation of the Constitution, they are all interpreted means that judges is quite commonly uses in also in Italy. And I think that this could be a problem if the right meaning is so far from the text and the scope of the law, of the statutory law, and especially regarding I don't know, for instance, the regulation of a very specific issue like the effects of technology into the society, where probably the law is easily outdated due to a simple reason of the time which the law was passed. I think judges is pushing by two different purposes. On the one hand, the judges must find the rule to decide the case, cannot just simply say this. Yeah. I could not apply or enforce the statutory law. So, and in this regard, the Constitution becomes a new, an additional means in order to find the rule for the concrete case. And on the other hand, so he must decide. On the other hand, he must carefully interpret the real content of the law. And so I think but on the other hand, for instance, through the duty to try to find the interpretation consistent of the Constitution, it's the same constitutional court that call judges to work on the meaning, on the literal sense of the statutory law, in order to find the more appropriate, the more consistent meaning with the Constitution. So I think there's a risk of a conflict between these two purposes, but I think it's something that judges must do, but on the other hand, must carefully do.
More question?
Yes, I like very much the idea of a dialogue, but I feel, after 20 years being a judge, that there are parts in this dialogue, real parties, that normally don't appear. We deal with evidence. And to say what happened in that specific situation, see, I judge labor law, so we deal with a lot of, like in family law or in real estate law, we deal with a lot of facts. And so there is a dialogue between the judge, the lawyers, the parties, and also testimonies and documents. So it's very hard for us to know what the truth is. And this conversation is very difficult. So I wouldn't be surprised that a great amount of what I've said as a judge would not be right, because I didn't know exactly what happened. So this difficult, you talk about storytelling, and the idea of storytelling, the idea of fiction, it's difficult. It's something different from law interpretation. It's something more related to the reality that we have to discover, the history that we have to rebuild, and this dialogue is also there. I always think that that's easier to say what the law means than to say what should be the result of a judgment, because then I have the fact. And that's the difficult part for me. And so I think that legal science should deal more about this part of the dialogue. And this, I like Kaufman very much when he talks about an analogy that's never perfect, because you are comparing things that are not equal. You compare the law with a vivid situation, with a lively situation, and you should say what that means, what's the result of that comparison and of this dialogue, a very complex one. So it's not a question, but that's just a confidence, something that I always... something that hurts a little bit when you have to decide. And, well, thank you.
May I something? I thank you very much indeed, Professor Lopez. I've never been a judge, so, but I perfectly understand and know what you're saying. And I think that you're perfectly right. The dialogue is not only between physical parties, but there are a lot of other parties we should find facts or just think about experts when they come to say, yeah. And normally also for our student the problem is, but what is truth? It seems that it doesn't exist, truth. And in certain sense of the word it is right. It doesn't exist a truth if we are thinking about a so-called material truth, the truth of fact. And I think that the most important thing we have to do is completely forget this kind of truth, because it is a false myth of modernity. It doesn't exist, a fact in itself. It exists a fact if we know fact, and if we describe fact, and if in certain sense of the word, if we construct a fact. It is not fact outside the knowledge of the fact. The fact is the knowledge of the fact. And so when we speak about, for example, storytelling, okay, different storytellings are possible, but not every storytelling is possible. And so also if we cannot ask to ourselves what exactly happened, we are obviously in the search for this kind of description, reconstruction of fact. And since exists different type of truth, the one we find in trial is controversial in its nature. So what we have to find to build a sound argument is just to have the opportunity to discuss the argument showing the basis, the ground for our description. And obviously, we can say that our description of fact is a good not or not because, for example, it is a good description according to witnesses or to documents and so on. But it is not the mirror of reality, okay? The idea of knowledge as a mirror is typical of modern era and is completely wrong. Completely wrong. There is no division between subject and object. This is a false myth for Cartesian, and we are son of that kind of thinking, but we have to dismiss this kind of mentality, okay, for myself. Thank you very much indeed. Bye-bye.
Thank you. We have still about 8 minutes on my wristwatch, and so if we have more questions, yes?
Okay, but I would have some questions related to the presentation on the first section that we have in the beginning of this afternoon. First is related about the judicial activism or activism of courts. And one thing that was I was quite, I would say, surprised is the comments usually comes in a negative sense, like judicial activism has a negative outcome. And I will, and I would like to ask you, like, in which extent judicial activism is not a response for the fail of the representative system. And I'm not talking about democracy. I'm talking about representative parliament, representative system, because this debate is not only in Brazil, it's not only Italy, it's everywhere. Not only in states, but also in transnational systems like EU. So my first question is related about activism and the relation of court activism and the fail of the representative system. My second question comes to your presentation, Professor Dimitri. When you first address the point that in the Brazilian Constitution has a peculiar characteristic in which is we have the general principles, but you also have several rules, specific rules that go so social and economic, and you bring this detail, this excessive detail of our Constitution, the reason why you have uncertainty in your legal system. And then my question would be like, I know that you are a positivist, and for a positivist, can I label you? I'm sorry, I shouldn't do that. It was my mistake. For a positivist, would comes and say, okay, if you have a system of principles and a constitution in which includes principles and rules in details, the outcome would be not uncertainty, but actually certainty. So perhaps what you were, I agree with you that the Brazilian legal system has an issue of uncertainty, but I wouldn't say that the reason is because our constitution is the detailed constitution, but actually we have another reason which should be carefully identified. So so I would have my question would be in this sense.
So I think we have many problems, but for me one central question is to find an identity for the law activity. What I mean, so I am legal positivist, yes, I accept this. And so for my point of view, I think the main value, the purpose of the law is the certainty, the previsibility, like the old Radbruch says more times. So if you think a constitution is a complex of principles, rules, what do you want, finalities, and so on, and the objective is previsibility, certainty of the law, then you must have methods of interpretation. So the real thing, the important thing is not, from my point of view, the dialogue between departments, powers, or courts, or to find because the dialogue has the idea of negotiation, the idea of consensus. And I think that if the law is a mechanism to have certainty and previsibility, so there is no place, there's really an utopia to think law like a process of dialogue between institutions. So if you want certainty, you must have an interpretive identity. The judges must explain the judge must explain his theory of law, his theory of argumentation. I think the starting point is to have, I don't know, I don't have any idea what is the best theory of argumentation, but I think the judge should begin his work with a theory of argumentation. Without a theory, a consistent, a clear theory of argumentation, can't decide. You are in the level of the negotiation, of the imprevisibility. So here is a identity question who must be decided before any discussion about the details of the Brazilian Constitution. So the main message of the Brazilian Constitution is the maximizing, like Professor Soraya says, the maximizing compromise. Everything stays in the Constitution, and then we must applicate, we must implement these principles. How? Then we don't need, I think, a dialogue or a negotiation forum between judges, legislators, or the international courts, a dialogue between systems to find a point of consensus. But we need a method of argumentation. So in this sense, I think the problem is not a problem of incompatibility between parts of the legal material of the Constitution, but the lack of a specific theory of argumentation for the judges and by the judges. So without a theory, no, the third time I say the same thing, without theory of argumentation. So because we have the old idea that the theory of argumentation is a theoretical problem only for law philosophers and so on. This is the beginning of any legal activity. If the judge loses his identity problem, and since I have a legal material, a real material, the stories, the witness and so on, and then I must combine this material following some rules, some argumentation rules, then you must decide about this technique, this method to decide on the cases. Without this for me, I am a constitutionalist and I have an ambition to be a legal philosopher or a legal theoretical, but I think that the main point, in this sense, Professor Trevisono, for example, has published a very important article about a structural analysis of the decision of the Supreme Court in Brazil in the homosexuality, marriage, and so on. This is a very important work to describe, to analyze the structure of the legal argumentation. If you find that the same judges in the same opinion has contradictory opinions, there are no line of separation, for example, between textualism, teleologies, or actualization of the Constitution, then the same judge has the first instrument for decision. So I think that the task of the legal theory, of the observation of the law in the first, second, or third order is to make a structural analysis, to analyze the structure of the legal argumentation, to find the internal, the logical, and the social problems of these spontaneous theories of argumentation.
In my understanding, the definition of the concept of judicial activism is not does not perform a negative sense per se, because I think it's something. Please understand me, something due in a constitutional order, especially when the democratic and representative institution is failing or simply fail in performing and exercising its own legislative power, because the judges still have to decide a concrete case. So it doesn't matter if legislator provide for a certain rule, or if it simply write down a bad law, which is very hard to apply. And also because in my understanding, the statutory law, not only my understanding, but I think it's something that must be clarified. The statutory law is not the law as a whole. The law, the diritto, the use, and the statutory law are very different things. So, especially if you consider it from a constitutional perspective. So, statutory law is simply one of the probably the most important, and maybe not in the present day, take into account the EU law system and the international one, but the main source of the use, but it's not the unique. So you cannot simply overlap the lex and use. I think if we approach this matter from that perspective, I think also the concept of judicial activism it can become more clear. On the other hand, I think, especially in Italy, or in general terms, in those legal order in which judges have a technical legitimation and not a democratic one, the reasoning becomes maybe the only source of legitimation of judges. So, in that sense, judicial activism can become a problem if, on the side of reasoning, if the reasoning is lacking. Because of, especially in the civil law system, judges are not representative. So they are not a democratic legitimation, but a technical one. So this is, I think, and also because we don't have the stare decisis rule. So the judicial activism, I think, is something in many cases due, or is simply a means that judges have to decide a concrete case. But on the other hand, when I think the importance of the reasoning and is also a means to guarantee the certainty of law, of the legal system, and also of the fundamental rights of individuals involved, because otherwise in a civil law system, this different judges or even the same judges can decide more or less similar cases in a very different way. So I think it's also in this case it's a matter of balancing, and I don't think that judicial activism is something that go against the role of Parliament. Paradoxically, when the Parliament fail in exercising its role, its function, that leave to judges the responsibility to decide. And so when the law is lacking or is a bad law, the judges lose a means for deciding. So I think it's not easy to put together the democratic institution, the role of judges, but I think that from a constitutional perspective, maybe if you consider both as part of this process of constitutional implementation, constitutional enforcements with different nature, with different purposes and means, maybe the picture is maybe more clear, but probably not more easy, but maybe more clear.
Thank you. I'm sure we can't solve all these problems here and now, but we have had a good discussion. The time is over, and I want to thank all the speakers, and particularly Alexander from Brazil, and all the others, and the audience. And I hope see you tomorrow in the morning at 9 o'clock for the second day of the conference. Thank you.
Well, regards to you, Alexander.